So welcome. Now you're all hyperglycemic. Let's talk about contracts. And so I hope I'll catch your attention. So as Andrea said, I worked for the research office before going to the TTEO. Now I'm a technology transfer manager for the life science. While I was at the research office, a big part of my job, about 60%, was dealing with the consortium agreements and European projects. And that meant liaising a lot with the TTO, because obviously there's a lot of intellectual property issues and other things. There's financials, different things. I don't have a legal background, but I had a lot of coaching with lawyers, which was a good thing. So you all know about Horizon 20. I don't really need to, and European projects. I don't need to introduce that. The motto is innovation. And Horizon 2020 is the financial instrument to promote innovation in the European sphere. You'll be glad to hear that the new members, such as Romania, always look good in a proposal for European projects, especially collaborative projects. So today, I really want to speak to you about intellectual property in these European projects, mainly collaborative projects. So this would be more in the societal challenges or Marie Curie ITN. Do interrupt me if you don't have if you have some missing information. I'm presuming you have a certain basis, but I'm happy to fill you in if needed. So don't hesitate to interrupt me. Yeah. So basically, with European projects, especially collaborative projects, there's a definite aim, and it's typically top to bottom, where it's the Commission that brings the call, and you have to come with a solution. And so they have in terms of contractual framework, you have the grant agreement, which is your relationship with the Commission, and they have a predefined set of rules, but there's a lot of flexibility in there. And then for each project, there's a consortium. A consortium means different partners. So you have partners from industry, partners from SMEs, and academia, and sometimes private institutes, like Fraunhofer. And so with all these partners, you have to set an additional layer of contract, which is actually very important, which is called the consortium agreement. And there's a lot of issues. Today I'm just going to talk about intellectual property, because this is the real link with innovation. But there's other issues you might want to think about in these agreements, pertaining to financial governance. There's a lot of little tricks you need to look at. So in terms of, I'm not going to go through and present to you, the consortium agreement. What I want to do today is present to you the key issues or clauses where there's always a problem and a divide between industry and SMEs and academia, and how do you bridge this divide, and how sometimes industry push a little bit more because they have an agenda, and obviously startups have one agenda and university another. So in European projects, so collaborative European projects, basically what you generate as results yourself, you own it. That's simple. The problem is when when there's a collaboration, you often can create joint ownership, because you work together on an invention, so you have joint results, and then you have to agree. You have to agree on how to go about it. And so the grant agreement gives you one rule, which is basically this option 1, and it basically says that by default, if you can't agree to a specific agreement between the co-inventors, then the co-inventors are absolutely free to exploit the invention, so you can sell, so you can use it, but if you're to license the joint results to a third party, then you have to compensate and notify the joint owner. Okay, and this this typically SMEs and universities are very happy with, and this is something they always push with. And then there's a second option, and so these two options are taken in one of the consortium templates, which is called the DESCA template. DESCA template's been thought and drafted by the LERO. Do you know LERO? It's a set of old universities committee and different actors. So basically they wrote this DESCA, and it helps a lot of people to streamline negotiations. And there's different options, and these are the two options you get in this particular template. But there's many ways of tackling joint ownership. So I'm just going to concentrate mainly on this DESCA type of template and how they. And so the second option is, basically, if we can't agree to how to exploit and use the joint invention, well, let's say we can do whatever we want. We're free to license, free to use it. Settle the costs, and that's it. And typically this is something that big corporations like, and atypically EPFL also likes. Because at the end of the day, what's important to us in terms of being in a joint ownership is that we're free to exploit our results. That's the most critical point. There's other reasons, and I'll get back to this later on. So big corporations, let's try and understand how do they function. Well, big corporations, typically they like this option 2, with this level of freedom to be able to do what they want, not because they often don't want to compensate, although the other joint owners and typically universities which they worked with, which can also, but it's often due to the way that the corporate structure. And time again, I've negotiated with IBM and likes of Philips and they're always constrained by their corporate structure. And so if you look at this here, this is this first circle. I tried to depict it this way. You have, so this orange at the bottom would be your corporate. You could say IBM. So it's interacting with the other partners in the consortium. And typically this would be an affiliate of a big company. So let's say this is IBM Switzerland. And what happens is that, IBM Switzerland, it has to transfer, whatever IP it makes, it has to transfer all the IP to all its affiliates. But first it has to transfer to the headquarters, which will then distribute all the licenses to its affiliates and sharing. And then often, in terms of the way using the results, they are often licensed to third parties, but not single licenses. It's bundles of licenses, many licenses, and IBM does that a lot, but also other companies. Obviously, this is just one corporate model, but it's just to give you a feel of the way of the divide. And so, typically IBM, it can't accept to having to notify each time and actually give a value for each license to compensate the joint owners. It's just impossible. Typically, and that'll be the argument. In fact, for them, it's if you speak to them, it's nearly impossible, and they'll say, okay, if you push them, they'll say, let's just publish the results, which okay, let's not patent, let's not protect it. We'll just put it in the public domain. And that's kind of the usual fallback. It doesn't always work with big companies, but that's one of them. I'll get back to third parties later on. Universities, they like option 1, as I said, for different reasons. One is return on investment. They need to ensure a revenue stream. And the second, and often this return on investment is even written in the institutional policy. Typically, if you negotiate with the CNRS, which is the French, one of the big French research institutions, is written, that they have to have a return on investment. And so, if they have the license, on the joint, they need to be compensated. Also, often it's just to abide to their national rules. So if you're talking to the lawyers in negotiation, they'll just tell you, in Germany it's like this. Notice that the grant agreement is construed by Belgian laws, including the DESCA. And typically, option 1 is basically a retake of of Belgian law and how to deal with joint ownership. And the French, the French also have basically written in their law that you should share the revenue if you license. So all these things that it's Europe. Everyone, all the institutions, lawyers, they all have their preferences in terms of law, and they always try to push it. And universities typically have this approach. SMEs, typically they like option 1, often simply, well, the problem with option 2 is that you're free to license, but you can also license the competition. So they've contributed on this joint invention, and then you're going to, there's a potentially you could license the joint invention to a competitor. And that's, typically the SME is like, well, that's not great. We would like to be notified, and even if possible, have a right of veto, And this doesn't work. But often this the position of SME is very defensive, and you can understand why. So EPFL, our position. Why don't we like option 1? Well, 1, it's typically, as I said before, we want to be absolutely free as a default. If we can't find a solution, then we just want to be free to use the joint results, and that's it. But there's another layer to this. It's just if you look at option 1, it's just unfair. It's saying, so I've collaborated with Philips. And Philips can use the invention. Use means you can sell. You can sell the invention because you don't need to sell. You don't need to give licenses to sell. So they can do this royalty free, make money. But if we, as a university, are going to license, we have to pay them and notify them. It's complete. The clause is completely asymmetric. And this is another reason why we resist this option 1, which is so fashionable in academia. And another reason is just the notification. As for IBM, it's just a burden. How can you be sure, that you remember to notify each time you give a license on this joint invention once it's patented? Okay. Well, I can give you one trick. I don't know if in your TTO offices you'll be handling European projects. Often TTOs do handle European projects. In fact, the EPFL TTO handled the negotiation of consortium agreements for many years until it was transferred to the research office. But if you do, one option which that worked in my experience, which is I've negotiated about 200 consortium agreements and the Human Brain Project with about 85 partners. So I kind of have a good feeling now what works. Typically on the joint, it's always good. I always push. Okay, we can't get to an agreement. Let's do it this way. Let's say in best faith with best effort, not even best faith, best effort, because it's even stronger. Let's give us 6 months. If we don't, then we go for the default. So when I say negotiate a joint agreement, how to settle the cost of the patent, and of course, how to deal with the joint with invention. And if we can't agree to a joint ownership agreement, then we should just be free to walk away off the table and use it and do what we want. Don't worry, I'm not going to. This just to say that there's other ways of in consortium agreements to be more specific about how to deal with joint ownerships, and often when you're negotiating with big companies, you get clauses like this, and it's there's many layers to it. I'm not getting into this, but it's just so you know. It's not as simple as option 1, option 2. So I spoke about third party, so transferring your own result to a third party. So often in this agreement, there's a specific clause about this, including in the grant agreement for European projects. And typically, well, with universities, the position of university and SMEs is that, okay, we'll waive our right to object that you transfer your results to a third party, but only if you list those third parties. And of course, big corporations, well, they say no. You know, we would just like to be completely free. It's our results. Why should we have to notify you? Why would you have the right to object? You know, and well, SMEs will say, yeah, well, you know, there's the competition, and you know, universities the same. I mean, there's different arguments. Honestly, EPFL, we're very flexible on this. I mean, there's not a great risk, but there's always a divide in this. Publications, well, that's very important. There's in the grant agreement and the consortium agreement for European projects, it's, you know, it's pretty clear. And the consortium agreement typically retakes the conditions in the grant agreement. And basically, if you're going to publish, you know, you need to let the interesting results. You need to let the consortium know. And there's a procedure. You follow the procedure of notification. And then, you know, if someone objects, then you get into good faith discussions and you try and find a solution. Well, EPFL, we always added one very important provision, which is that, okay, we'll get into these good faith discussions, but in any case, you know, after 3 months, we have to be able to publish the results. And the reason is because if you don't do that, and I had many discussions with that with SMEs and even big corporations like Philips, in fact, who are quite pushy about this. They'll say, well, no, we don't want a time limit because, you know, say we have a patent, you know, we want to keep the confidentiality at least, you know, 18 months. So yeah, let's you know, push the limit, not 3 months. Maybe we can have it 18 months, but it's too much, you know. So here too, there's a divide between SMEs and industry, which are trying to keep everything confidential, you know, and academia, who needs to publish, you know, to exist. And so this particular provision on the top in red about this 3 months, in fact, in the last version of the DESCA, they added it in the main template, word for word, the EPFL version. I'm quite happy about that. Yeah, I should. Access rights. So this is the this is the killer for innovation. This is why European projects have limited scope in terms of innovation. There's the whole big word about innovation, but in terms of instrument, it increases the level playing field, but you know, for creating startups, it's not great. So the problem with European projects is the access rights. So access rights is the access you give the rights of access rights to your results or to your background, which is the results you had prior to joining the main project. Okay. And access rights, well, on the results, or even generally, they're given on a non-exclusive basis. That means that potentially every partner could have the same results, access to the results. Okay, so you can't give. It's very hard to give exclusive licenses, and obviously, you know, to create startups, you need, or to do something, interesting with the technology, you need an exclusive license. Having said that, it's not completely impossible to have exclusive licenses in European projects. I mean, I've seen a bit of creativity. Typically, well, I've seen some coordinators trying to push exclusive licenses, but it never works. What works, you can go for an option, an exclusive option. It depends again on the technology, who you're working with, but that's a possibility. And yeah, or maybe exclusive just for certain deliverables. So there's some freedom, but it's very limited. Also, I mean, in terms of giving access rights, obviously you have to prove it's needed. So, you know, if you didn't have the access rights, you wouldn't be able to use your own results generated during the project or exploit it. Oh yeah, and of course, for the results generated during the project, typically there's a 1 year limit to be able to request the access rights, and you often see that big corporations will push to 5 years. They'll ask, no, we want 5 years just to be sure. Whereas, you know, SMEs say, no, we're just limited to 1 year. The possibility to request access rights on our results, and it's the same for universities. We always put a window to 1 year. Okay, background. Well, background, as I just said before, so exercise of background. Background is all the intellectual property and results you acquired prior to joining the project. Typically, you know, if this intellectual property or know-how is important for the project, then you should list it. If it's very sensitive, you can exclude it even. And in the past, so there's a specific attachment for that, so you fill it in. And in the past, typically, there were two coexisting lists. So there was the the intellectual property you wanted to include that would be necessary for the project, and that you wanted to exclude. The problem with the idea was that you could include something, but you could, you know, use the exclusion list to exclude something that, you know, precisely that you didn't want to include. Well, it didn't really work. I mean, it's something that was very legally ambiguous, and so you'll see in the last template there's just one inclusion list, which means that whatever you've included or whatever you haven't included is excluded from use. So it clarifies things much better. There's no and typically, yeah, access rights. Well, to background. So if partner needs to exploit, you know, results from the project, he can ask access rights to the background, but as long as it's listed, and typically this would be on fair and reasonable conditions, which means, you know, there would be a price to it. Yeah. Okay. In terms of access rights to the results, so results is foreground, yeah, just in case I hadn't in FP7. So if you need access rights to the results generated during the project, industry will always say, yeah, we want it royalty free, you know. And the reason is because, you know, they're already bringing 50% of matching fund. They don't get their costs fully reimbursed. Like, you know, we're already investing in this. Like, we want, you know, it's only fair that we get royalty free. And obviously, well, SME, well, academia especially say, no, you know, there has to be a price to this, you know. So again, that's another divide you often have to bridge. And another issue is so that side ground, which you often see with big corporations often go into projects to fish large. Typically, they go into European projects because they want to be part. They want to know what's going on, and they want to be sure that they can contribute to the standards in the field. And so, in their fishing large in intellectual property, often they say, you know, if there are results. So results which have been generated during the project, but haven't been financed by the commission, so by the project, we won't have access to it. And so this specific type of result is called side ground. Okay, it's a little bit subtle, but it also means that it's very dangerous for universities, because this means that potentially, you know, it could be you know, results that are funded on another project, perhaps even by an industrial project. So there's a lot of third-party rights that, you know, and this is something we always say no to. And I think most universities say no to. Okay, export laws. You might say, oh, this sounds very boring, which pretty much is. But it is an issue. Export laws obviously means, controlling exports from your country. When you're just under your own national rules, it's fine. The problem is, and this is from EPFL experience, it's when it's American export law. This is the problem. American export law is very pervasive. You found it in all big corporations. Very contagious. In fact, if you're given, something under export law, on your computer, you go to China, you're liable for retransfer. If you share something sensitive with an Iranian student, you're liable. That means, this means, under American law, a professor could go to the United States, get arrested. Or for us, it's even more sensitive here because we have funding from the United States and lots of collaborations with a lot of professors here have been in the States, have a lot of collaborations. So it's something we're very careful with. And typically in European projects, sometimes, once in a while, you get export law clauses. I mean, this first one is a typical one. The only thing you do with this one is remove states, which implies United States, and put countries. I'm just going to skim the surface. I mean, I don't want to bore you with any details. Sometimes you get this type of clause, which is basically saying this is all about US export law here, and we say no. And this one might be interesting for you because this is Fraunhofer, who's been pushing a lot this clause on, and there's a good intention to it, but it's actually drafted very badly. In that, basically the intention is that it says if you find out that you're under export law restrictions, then you can you can terminate your participation in the project and not be liable. This is great. Okay, why not? But then it says, it acknowledges there's export laws in this first paragraph. It says there are export laws. We could probably give you things under export law, but in fact, we don't even warrant that we'll give you a license. So this actually was a problem. I was in a consortium agreement with all these partners. You can see there a lot of big names, and ESA was the coordinator. Now, EPFL, as I said, were very sensitive with this issue for different reasons. And in fact, I found myself alone negotiating with ESA, and there wasn't much support in the consortium. So luckily, we got to consensus with ESA, which basically, okay, if you're going to give us, so basically where we corrected a little bit this clause, which says that if you're going to give us export law, at least tell us so we can deal with it. Then we can have a black box. Then we can do something with it, which is basically what's written here. Well, it turns out that Thales, then after 2 months of hard negotiating with ESA, it went tilt in their hand, and they told ESA, no, we can't sign the consortium agreement. And again, this project was actually really sensitive because it was about 3D printing for nuclear plants, aeronautics, everything that's under US export law, And we were the only ones, saying, guys, there's a problem there. Why do we have this clause, and it took me 3 months, and then Thales, and then a few others, it started working in their hands. So it's to say sometimes it's not so easy. There are some states. I don't know if I really need to get back to, this is just concluding remarks, but I think I've been through all the points. So there is a divide between large industry, SMEs, and academia, and you have to try and find creative solutions to bridge the gaps in these consortium agreements. Again, the agreements are always construed by the grant agreement. So it's not at the end of the day, there's flexibility, but not so much. And as I said before, the TTO used to manage them, and then it was transferred to the research office. where I worked, but it was always in very close collaboration with the TTO for the intellectual property cases. So I don't know if you have any questions, maybe I can answer them. If not...
I have a small question actually. Is it possible to have the print or something?
Yeah, of course, yeah, of course, yeah.
Because it's
yeah.
A lot of
You can read the clauses in your own time. That was the intention, in fact. I didn't want to, yeah.
What's the status on Switzerland with the Horizon 2020? Are we part of it or not?
No, we're part of it and not part of it. In the sense that we are able to be, so all the collaborative projects, we can do them. We can participate, there's no problem, but we cannot coordinate any projects. So that was a little bit, it's a little bit of an issue because, as you know, we have one very big European project in this school called the Human Brain Project. It's, I mean, the overall value is 1 billion. Obviously, it's not 1 billion to EPFL, it's 1 billion spread. And, so it's an issue there. But they're finding solutions. You know, like Roland was saying, you have to be creative. Well, the politicians are trying to be creative, finding creative solutions. The main issue are the ERC, so mono-beneficiary grants. Because the ERCs in this school, they've been very successful. I mean, I think we're the 3rd or 4th in Europe for getting ERCs, and it basically brands excellence, ERC funds, and it was a very good. It was a very good promotional tool for the school. So to answer your question, it's mostly the ERC grants which are a real problem for the school. Maybe I can just for your general knowledge. I mean, we discussed this before. So I only spoke about collaborative projects under one of the pillars of Horizon 2020, but there's actually other tools to promote innovation which are probably even more interesting. And one of them is, it's not exactly under Horizon 2020, it's under Eureka, but it receives money from H2020. And that is more, it works more like the CTI projects, but it's even better because everyone gets money. And there the intellectual property is much, much more flexible. There's no written rules. And so yeah, the negotiation is a bit harder for when you do the contracts, but it's more interesting for promoting innovation. And in fact, that's what Eureka is about. It's really, you know, transferring technology to society. And then I think they've kept it under Horizon 2020. It used to be called FP7 SMEs. So it was a tool that was specific for SMEs. And the purpose was that it was to allow SMEs to access know-how and equipment and technologies from, you know, universities. And the scheme worked this way: is that the SMEs would receive funding from the commission, and then the SMEs would subcontract the universities for a certain technology. But so basically, universities were under a service contract. So all the IP would go to the SMEs, and you know, you could put your price. And we had a few here. They were a bit of a headache because, you know, it was very new and massive headache. In fact, I even also because I don't need to get, also because of the finance. But anyway, it's still an interesting tool to promote innovation, which is it's worth you know, investigating. So here we go. I'll take any questions later, one by one anyway.
You mentioned CTI. I mean, when you have more freedom, do you actually aim to have I mean, is your ideal IP structure, configuration, is it the same for EU grants and for CTI grants? Or do you actually aim for different kinds of configurations, given that the projects themselves are have different objectives?
They're completely different. It's completely different. I mean, CTI and European projects have nothing to do. You know, they're completely different in terms of IP. How do you tackle it? I mean, if you want, the only requirement with CTI is that the company has a non-exclusive license, and then you can negotiate an exclusive license, you know, with a price. But you know, so that's the only underlying rule with CTI. With the European project, there's more layers to it.
Yeah, but I'm talking from your perspective as EPFL. You would like to have these be. I mean, if it was just up to you to do whatever configuration, would it be pretty similar, or you would actually want CTI things to be different from the European ones? Just, you know, supposing you could do it, you know, supposing that the EU would allow you to do whatever you want, to negotiate whichever way you want, because it just seems, I don't know, the EU grants seem to be a little more fundamental, the CTI grants, and it seems like it's different objectives.
They're completely different objectives, yeah, exactly. Okay. Although, as I said, in H2020, there are tools which are similar to the CTI in that they're trying to promote, you know, a transfer of technology to the society. But again, CTI is Swiss. It's a Swiss instrument for transferring technology to industry.
CTI is easy because you usually have one partner, and so it's a one-on-one negotiation most of the time. So I think it's really easy because you only have to take into account the requirements.
But you can have multiple partners. I mean, I've seen a few with multiple partners too. Yeah. But it's very flexible.
If it's less than 10 partners, it's a really small one. So it should change entirely.
Yeah.
What makes it difficult with European contracts is that there are so many partners and they don't sit together in the same room with a very clear picture of what their ultimate objective is and really sort it out from the start. So they go into this negotiation.
So yeah.
You don't know what they want. And it makes the whole thing messy because it just generates these access rights all over the place that pollute and all of the research, and you have to, all you can do is basically pull out your background and make sure that it doesn't contaminate the rest of the research. Whereas in some cases they would have potential to create something really interesting because you have all these parties, they have all these complementary skills, and it will generate something with high industrial relevance potentially. So if you just sorted out the rights right from the start and said, you know, you get these royalties, you get that royalties, and you are co-owners and you are not, you can do it up front because in theory you know where you're going.
But in theory, it's done. What you're saying is actually it's done because, you know, the guidelines are in the proposal. So the description of work, which is binding, is Annex 1 of the grant agreement. You have to delineate your IP strategy. And sometimes they're very specific. That's why you should always read the Annex 1. But yeah, no. But this is the point. This is the point here. We try to have, you know, the whole view. You know, but it's more about managing risk. Honestly, it's more there. But like with the Human Brain project we had, you know. Again, but it was in the Human Brain project. It was much easier because there was there was one industrial partner, SAP, and you know there is suspicion between academia and industrial partners always. You know they're here to steal, take away all that. There's suspicion all the time. You speak, I mean, I had one of the technology transfer, or I don't know, one of the heads of University of Vienna, who phoned me. Actually, phoned my boss, and then she got me on the call. And because I was promoting, I was pushing for the option 2 of the joint, for joint ownership, so without return, the licenses and all that. And he's like, what are you doing? You're selling university. You're selling yourself to, IBM. I'm like, no, we're not. This is our position, And there's suspicion. There's a real divide. And so with the Human Brain project, it was very easy because there's one. Okay, there were 85 partners. And many more now, but one industrial partner, and in this case, we asked all the partners to really list very precisely the background they needed, and we put a whole scheme, and we're quite organized there. But it's true, this is probably one of the only projects there's been others, but where, you know, people were, you know, the coordinator, which was us, was very diligent in making sure all the key background, you know, intellectual property was there, so that, you know, you can do something later on when you exploit the results.
Is there anything in your presentation that's confidential? You put a lot of legal text up there.
No, all this is.
Okay. Because we're gonna.
No, all this is public domain.
Questions?
No, thank you, Adam.